The Honorable Chief Justice of Pakistan, the Chief Justice of the Lahore High Court, the Honorable Judges of the Lahore High Court, the foreign delegates, advocates, ladies and gentlemen, Assalamu alaikum. I want to first of all thank the foreign delegates who went through a lot of inconvenience getting to Lahore. I, on behalf of the judiciary, also want to thank them for coming over, sharing their ideas with us. I think it's one of the most critical areas of reform in the country right now. I think it's high time that we move to ADR. I'll be just sharing some statistics with you later on in the day. It's perhaps if we were to talk about one main reform that this country, judicial reform that this country requires, is to migrate onto ADR and to inbuild that into our system. So thank you so much for being here. I missed the earlier sessions where you deliberated on rather very important areas, and I'll probably get a link and go through those and make my notes. I'm sorry I was busy with some professional commitments and couldn't be here earlier to go through all the panel discussions. I'm sure they were very useful, very meaningful, very wholesome, and there's a lot there to learn from. So once again, to all the foreign delegates who've traveled from all those countries, thank you so much for being here with us and to share all this experience with us. Thank you to CIArb for inviting myself to be here with you today. Thank you so much. I've been tasked to, well, my focus is domestic ADR actually, and I want to talk about the present state of litigation in the country and see how ADR fits in and how it could revolutionize and change things. And that's how critical and how important this conference is to me. To me, it's like a watershed that could be a tipping point. And if we pick up this momentum that arises today and just go on with it, I think with the help of the Honorable Chief Justice of Pakistan, who has his interest and heart in it also, we could really turn things around in no time. And that would benefit that ordinary litigant who's not in this room today. So this is all for that ordinary Pakistani who goes to court and waits and waits and waits years and years for his case to be decided. I think we might just have a solution. And I think it's about time to embed it seriously into our system. Even though I've been tasked to talk about Pakistan's struggles, or perhaps Pakistan's struggles with ADR, arbitration and dispute resolution, I think with this momentum that I see here and the energy and the expertise that I see here and the tipping point that I see right in front of my eyes, I would rephrase the topic and say Pakistan all geared up to provide ADR for Pakistan. So it's time to enhance the dispute resolution mechanism, the alternative dispute resolution. We need to think that there's a world outside courts also. This is a major mindset issue to my mind. So we've talked about the earlier project, and I'll talk about the ADR initiative that we took at the High Court. It's the change of mindset. People need to understand that they can resolve their disputes outside court. This is a deeply embedded mindset which needs to be broken. And I was very glad to meet some young people who said they are young mediators from various law colleges trying to do some awareness program. All strength and power to you. I think awareness would be the first step towards a domestic ADR revolution, if we were to use the term. So this is not out of the goodness of heart that we're talking about ADR. I think it's not anymore a fancy sideline discussion or a side attraction anymore. I think it's a hardcore mainstream reality, and we need to understand that, especially for Pakistan and the figures that I'll share with you. So it's about time to seize the moment, and I say it with all seriousness, carpe diem as they say, seize the moment please. We need to do this, and I urge the Chief Justice here, the Honorable Chief Justice who's listening in, this is perhaps the time to go in with all force and energy that we have in understanding and embedding ADR into our system. So it's with passion that things change, not with positions, I must tell you. So it's with this passion that I want to address you today and tell you what my ideas are and how I think we could make a difference. Let me start off with the constitutional plane and see if we can play around with some of the ideas, some of our fundamental rights a little, and tweak them a little if we can. So let's look at Article 9. You see, Article 9 is primarily in our Constitution for foreign delegates. Article 9 talks about right to life, but jurisprudentially over the years we have given it another meaning, and a subset of it means right to access to justice. So access to justice comes out of right to life, Article 9 of the Constitution. Now access to justice, we all understand, talks about the ability to be able to approach a court of law. I think we need to add to it. I think we need to revisit it, reconfigure it perhaps. And access to justice by just getting to court is not enough anymore. If I get to court and have to hang in there for 20 years, is that access to justice? Aren't we not really frustrating the very concept of access to justice, which is connected actually and arises out of right to life? Is my life not impaired if for the last 20 years I'm stuck in the court system? So I think we need to retool it. Right to access to justice would mean when I get a decision, when I'm out of the justice sector. So I think this pushes in the concept of ADR also at a constitutional level, that if we're talking about right to access, we're talking about right of conclusion of your dispute. If the dispute still lingers, access to justice to my mind means nothing. So maybe we need to reconsider this aspect. We need to also consider the fact that right to access to justice which arises out of right to life perhaps is also saying that if I have an easier way to resolve my dispute, I am not supposed to be put into the rigors of litigation. As a fundamental right, I have a right to a fast-track dispute settlement. Does it not impair my life if I keep going through the litigation process without even exploring the option of mediation, without even exploring the option of arbitration? I think it becomes a right that I be first given the right to go through this process, and as a fundamental right arising out of Article 9, maybe at a time we could say that yes, it's a right of a citizen of Pakistan to say I want a fast track dispute resolution. If I were to fail in mediation, if I were to fail in arbitration, then I will end up in litigation. But to throw me into litigation straight away, perhaps now we might consider impairs right to life and right to access to justice. The other concept which I think is also important and we need to talk about is Article 10A. We talk about fair trial in the Constitution. We talk about due process. And let's not be sort of stuck on the word trial to mean trial in the court of law. I think fair trial, and it's about time that we tweak it a little. Fair trial would mean any system that settles dispute. Any dispute resolution mechanism would be fair trial. So it's about time that 10A includes ADR for sure. For sure ADR is included in 10A, and perhaps more. It also says that it is perhaps more fairer, and perhaps it's more closer to due process if I were to take the easy way out to settle my disputes. Would it not be easy for a citizen to get out and get back to his life and just get done with the court and justice system? So perhaps 10A and a fair trial inherently also talks about a fast track system to be opted first rather than going into litigation. So we need to start looking at Article 9, Article 10A, right to access to justice, right to fair trial, and right to due process under the Constitution with kind of an ADR flavor, which actually, if you go down to the nitty-gritty, it actually changes the way an ordinary person's life is affected. Because if he's just thrown to the courts, he might not be able to get anywhere, or it will take so many years, the cost, the time, and number of other problems that come with it. So we could start off by sort of revisiting how our constitutional rights talk about the concept of ADR. But let me tell you why I'm worried about this, why I talk about ADR with this kind of interest, because let me share with you the litigational landscape of Pakistan. You need to understand where we stand. What is the problem in the country? So according to the Law and Justice Commission of Pakistan, the recent statistics as of March 2022, we have 2 million cases pending in Pakistan, 2 million. And we have 4,166, rather odd number, 4,166 judges in the country dealing with 2.08 million cases. Out of this lot, the Supreme Court looks into 2.5% of this backlog. The high courts are looking at about 16% of this backlog. But where is the real fact? 82% of this litigation is nowhere but with the district judiciary. Our frontline courts are handling 82% of our litigation in Pakistan. So the High Court across the country has about 145 judges, which, if we were to divide the work that they're doing, brings down their docket to around 3,000 cases, which would perhaps be out of sync if you compare it with any international benchmark. 3,000 cases in the docket of a judge. Now, what does that really mean? You see, if I handle cases every day and I decide cases, if I have to write a couple of judgments which will take more than a day, it might take a month. I mean, there are Supreme Courts in the world might take months to write a judgment because Supreme Court is settling down policy and they need to think a lot more. So, suppose if I have to write a couple of judgments, then those cases get delayed. As far as my disposal is concerned, or the figures will show that this case stands decided, but I'll be sitting on it for about 3 to 4, maybe 5, 6 months writing that judgment. So it stays back, and then I have new work that comes in. So this docket is very important. You need to understand it is this 2,000 or 3,000 cases in my docket which doesn't go away. It's not easy to get rid of this docket because you're writing judgments which are pending and there's new work coming in. So as if this is going to stay, there is no way out of it that I can get rid of this docket. It's not possible. If you look at the district judiciary, they have a docket of about 1,800 cases a judge. And I'm talking about the district judiciary. This is 1,800 cases per judge, and every day new cases are coming in. They are putting judgments that have to be written, and maybe that's also adding to this number. So it's not 1,700, it might be more. It keeps adding. So there seems to be no answer to my mind that how do we get rid of all this. Within the district judiciary, that's 1.7 million cases that they're handling. 67% are civil cases, which take longer than the criminal cases. Criminal cases 32%, but 67% is civil litigation in the country, which perhaps is ideal fodder for ADR. So going down to civil judges now, which is the actual frontline court to my mind, the actual fat of the district, of the entire pyramidal structure that we have of the judiciary. The actual set of cases are with the with the civil judges, and so civil judges / magistrates are about 2,828 judges in the country. 2,828, and they're handling a pendency of 1.4 million cases. 752 per case per judge in his docket. And I don't know how, under what formula could those 752 cases going to disappear one day and he end up deciding, because every day you have fresh cases coming in. Rough understanding of the institution and disposal is as follows. The recent figures show that a judge might decide, a civil judge might decide about 85 cases per month, but he has an institution of 85 cases per month too. So what is happening as zero sum at the end, you see? So he's still, struggling with those 752 cases. He has to write judgments, something more comes in, and we're not talking about the quality of work and all that. So this system is stuck. That's what I'm trying to say. It's just stuck there, you see, and it's not moving. The categories of cases in the civil would be civil suits largely civil suits, family disputes, guardianship matters, rent matters, and commercial cases. So if we look at the pendency, and this is worrying, I am telling you this is worrying. If you look at the pendency of Pakistan's backlog, in 2010 it was 1.3 million cases. But if you look at 2021, it's 2.1 million cases. So it's growing for sure, the figures are saying. It's growing. That very docket that I talk about must have grown also. So that is the state of affairs that we are at. The average time, I would imagine, it's anybody's guess for that matter. I try to look at the statistics. We don't really have a calculated figure on it. But the average time a case would take from civil court to the Supreme Court, which will exhaust the entire justice sector, the litigational space that we have in the country would range from 5 to 20 years. We're talking about a generation lost here. So it could vary, of course, but that's the kind of figure we're talking about. And there is practically no domestic arbitration, and there is no practically formal mediation outlet to this. So there is no alternative as such, and I'll talk about why not. But currently it is, one could make a statement that other than litigation, other than filing a suit and going to court of law, you do not have an alternative available to go elsewhere because of the problems that the alternative offers, which I'll explain in a minute. So I think while if we sit down and talk about judicial reforms, we say, how do we sort this out? 2.08 million cases, number of judges all pointed out, and the way things are stuck, what do we do? So we look at other things. We talk about bringing information technology, going into case management, working environments, training and all that. But one very important reform out of all this would be to set up Adr Center, migrate these cases onto mediation, give the option to a litigant, please you can mediate this matter in a month's time, or if not, you could arbitrate this matter within a couple of months and be out of the system. No appeals, nothing. You don't have to go and visit the Supreme Court in Islamabad. You're done with the matter right here. I think this could be a fantastic alternative, and anybody would find this to be perhaps the most important reform that the country requires at this stage. And that's why I think that this conference is so critical and so important. I'm so pleased that Honorable Chief Justice of Pakistan has blessed this occasion of this presence to highlight the importance of this area to the nation itself and to judiciary also. So, to my mind, mediation is the beginning, you see. If we were to look at the ADR, my experience tells me that mediation would be a start to change the culture, because arbitration and the Domestic Arbitration Act of 1940 has deeply affected people, have pushed them back rather than bringing them into the fold of arbitration because of the interventionist policy that the courts enjoy under that law. People think that it's going to court twice if I were to invoke arbitration under 1940 Act. I would first spend time with the arbitrator and then spend yet a couple of years at the court. So it's like doing it twice in a way. I would rather go to the court rather invoking the 1940 law. So that might be some flaws with the 1940 law, but my experience tells me, and as the Honorable Chief Justice of Lahore High Court has earlier mentioned, we had the chance together as a teamwork. We came up with a mediation project in the District Judiciary of Pakistan, Punjab, and that was based on the same ethos and sentiment that what do we do? How do we break this glass ceiling and sort of move on? And there was no legislation at the time, by the way. So we administratively thought that it's very simple. The model was very simple. Let's establish a court. Let's get a civil judge trained in the art of mediation. There were local mediators available, some of them sitting here. And then there was CIArb who sort of helped us with training some of our judges. So let's train some of the judges in the art of arbitration. And let me tell you, as a matter of background, the law schools don't offer courses in negotiation. It took us some time at LUMS to talk about having courses in negotiation. It's a very sort of adversarial mindset that the lawyers enjoy. And there are laws which say don't bring a lawyer into this dispute settlement because it will probably never end. So we need to start changing the mindset of a lawyer. A lawyer is not supposed to be adversarial all the time or confrontationalist. They can also negotiate and settle matters. So the background, the law schools, the overall history of the bar associations has been more adversarial in character, and that also was a stumbling block for us to sort of market mediation in the midst of all this. So we started off this project. We said, let's train some of our civil judges and start telling people that, and the judge who's hearing the case will give an option, voluntary of course, would give an option that before the next date comes up, I mean God knows there are about 120 to 200 adjournments in a case anyway. So before the next date comes up, we give you an option. Why don't you go to that room next door, that nice little colored place? Go there, there's a nice coffee and tea being offered. Just go there and maybe your dispute is settled. There's a judge who's sitting there who will talk to both of you, understand your problem and resolve your dispute. So people started understanding this because they were already stuck there for a number of years. They thought, what's the harm in trying an option? You see, we'll get back here after a month anyway. So people started moving, and this is all done under Article 203 of the Constitution, which is, our own practice of High Court rules and orders, and we just said, let's go ahead and set this up. So we set something up in 2017 in Lahore, and 2 mediators received 110 cases at that time, and out of which 60 were successfully mediated. I think that deserves a clap. That also gives me a little break. Okay, so then what we did was that when we saw that this first arbitration mediation center set up in Lahore, we sent 110 cases. We sent them 110 cases, 60 were decided. We thought this is making sense. The model works. So we went ahead with 36 districts and set up ADR centers, started training judges on the site. We felt there was a response and we said, let's go for it. And we sent them for international training. They went all over the place. Asia Foundation, thanks to them, they were there to help us out. And we sort of did a lot of work on their training and capacity building. Excuse me. So what was the performance of the ADR Center? That's very important. So since 1st June of 2017 to 31st of January 2019, we're talking about 20 months, 30,688 cases were referred to ADR, the mediation centers, out of which 14,239 references were successfully mediated. So success rate was 45%. So this could have some cases which were purely ripe at that time and they were decided. There could be, you could put a little discount factor to it, but 45% cases were mediated at that time. And people started understanding what was happening. What we did was, we started at the same time an awareness campaign all over the districts by putting up banners, so the litigant who walks into the courthouse would look at these banners and it registers that there is an alternative for this also. We could go ahead and settle disputes through a multi-door courthouse concept rather than just one door which leads to court. There are other doors that open into mediation, into arbitration. So the culture started changing. It was important. People weren't sure that this could also happen. They thought you have to get a lawyer, you have to get a judge, that's the only way. No, you still get a lawyer if you want, you go to another forum and you can get your matters mediated. So that was a very encouraging thing. So we fast forward to 2022. Things are now off the ground more formally and more institutionally. I'm so glad to announce that. The legislation has come about, and I think they might have seen all this experience at Lahore also. The legislation comes around and we have the Islamabad Act and we have the Punjab Act and the KP Act and the Civil Procedure Amendment in Sindh. So all the provinces are following suit and they've come up with legislation. It might have problems. Legislations have problems at times. They're probably not standardized. There are issues which are missing in some, and that's a matter we can sit down and talk about. But the first positive thing is there is legislation. One of them talks about a mandatory ADR, which is very encouraging. However, on a very light note, some of the legislation coming out of Punjab and KP talk about the word alternate dispute resolution instead of alternative dispute resolution. So I think the word ought to be corrected. It's alternative dispute resolution rather than alternate dispute resolution, but somehow the law misses that point, but that's just on a side note. So of course there are differences, and I don't need to get into the differences. What I'm saying is the ADR legislative design has been set in, and we could now, with the help of CIArb and the expertise we have under this roof, and there's experts sitting here, could use the international mediation rules and try to look at the overall legislation that we have, come up with rules, standardize the whole area, and come up with a model mediation law in Pakistan, which is not rocket science to my mind. We have a model rules, all internationally available. We have the expertise here. We just need to sit down and talk about it and talk to the government about it in the legislature and see how we can sort of, and I don't need to get into the details of standardizing them. We could have mediation law put in place, and we need to start working on the mindset of the people that now it's by law, it's there. It's now a mandatory requirement. Every time you come to court, you're asked to go to that room, which is there. And I'm talking about court annex. That's the experience I have. I'm talking about a court annexed ADR. Of course, the law would also imagine an ADR center anywhere in the city where you can just walk in to an ADR center, which is fine. But my model and something that I'm talking about, which I think would be the first step, could be a court annexed one, because a lot of people still associate dispute settlement with a judge. You see, they think, let's go to a court, let's go to a judge. So a judge sitting as a mediator, and my experience tells me when you talk to some of the people, they said, no, we would want a mediator to be a judge. We don't want a mediator to be a local resident or, you know, somebody else. We feel more comfortable. That's the initial response that we got when we did a bit of a small survey at that time. So yes, that's how the things come in. So mandatory legislation and formalization of the arrangement, I don't see a problem with it. So the model could be that we could get back to our, and the Honorable Chief Justice is here and the Honorable Chief Justice of Pakistan listening in, ideally, sir, what we can do, and this is with this legislation in place, some of the legislations have not yet been put in force, and that can be taken care of, should not be a problem. We could sort of tweak the laws a little, talk to the government about it. They should be interested. Why would any government not want to reduce litigation? It is a win-win situation for everybody. So we could talk about setting up ADR centers in every district of Pakistan. And the first part of the ADR that gets operationalized could be mediation, and get going with that. I mean, that starts changing the culture in the districts. People start understanding that there is a concept, there's an alternative available, and we can go change things. Now coming to the domestic arbitration. Now that has been, and I started looking for cases, and I asked the Law and Justice Commission, I asked some of my other colleagues working in high courts to could we find out how many cases are there in the country dealing with arbitration, domestic arbitration 1940. And I'm sure there are cases, but they're not being recorded as such. There is no formal, credible data that I can speak about. It's not a category which talks about so many cases in arbitration are stuck here for being rule of the court or any other matter relating to arbitration. So, to my mind, as I see it, with whatever statistics I understand, I think it is quite a dead horse. You see, nobody is really doing any much of an arbitration under 1940 Act. And this law needs to change. This law has to change. This is the first reform that can take place as far as arbitration is concerned and domestic arbitration is concerned. The 1940 Act has to change. And we don't have to really go far. The UNTITLED and the other model laws are available. CIArb is available. We can start looking at this and see, providing procedure for arbitration, rules for arbitration, and the intervention of the court is the first thing. I mean, it's me as a judge who needs to take his hands off arbitration. I need to take my hands off mediation. I think this is for me. And I need to tell my judges that stay away. Let arbitration bloom. You see, let them conclude the matter. It's the time. It's very important. It's the cost. And let the award be looked at with some limited areas that you have to consider. But it's been, somehow a tradition overall that you see that the courts interfere at every step of it, which is under the 1940 Act, and I think the legislation needs to provide for it, and we need to move ahead. We also need to, and doesn't concern me, I'm not talking about international arbitration, but as far as the laws that I see that the country must have, we have these bills in 2009, which is still waiting on the shelf, and 2015 bill also, which kind of puts everything together. It brings in domestic arbitration, it brings in international arbitration, it brings in the enforcement of foreign arbitral awards, and the center perhaps as one big law. I think that could create a lot of problems. As I look at it, I think we need to go with separate laws on these areas. That too should not be a problem. We just have all the laws available all over the world. We just have to put the ministry and the government to work, have a negotiation, talk to them that we need laws in the country dealing with domestic arbitration, domestic with international arbitration, dealing with the enforcement of foreign awards, and also a law that deals with setting up an international arbitration center. Should not be a problem, and we can do that. So we need to move in that direction also. So as a future, I mean, we as you see, the 2011 Acts, the two laws that have come for the enforcement of foreign arbitral awards, are doing a good job. I mean, there has been some hiccups, and we probably were looking at a recent case of the Supreme Court. That probably gets decided sooner or later. But I think some way has, things have opened up for the enforcement of foreign arbitral awards, and maybe as the jurisprudence settles, things will improve on that account too. But what I really want to stress and underline is the real fact, the real problem of Pakistan's litigation is the civil court, where cases are pending years on end. Mr. Karamat earlier pointed out that it takes years. An arbitrator might come up with an award, but then you have to sit and wait for years because it has to pass through the justice sector and those tiers, and that takes years, and that has to go. So the future, as I see, as a singular reform for the country would be to ensure that we have mediation law in line, that's number one, and go ahead with ADR centers in the country across all the districts, and maybe some of the districts which carry a lot more business and there's a larger economy like Sialkot, like Multan, like Faisalabad, there the arbitration center or the ADR center would also have within it a bigger commercial kind of an area dealing with the matter, but the design remains the same for the country. And some of the big centers where there's a lot more economy, stronger economy, you could have a bigger ADR center for that purpose. So mediation, legislation to be put in place, the laws that are there have not been yet actualized and not enforced, need to do that. Standardizing those laws with the help of the government, sitting down with us, talking to us about it. The Law Commission is there, the ideal forum which could sort of look into this area, and with the expertise of CIArb, we could talk about, standardizing these laws, and then moving on to setting them up, and then taking up the arbitration, domestic arbitration, as another angle, as another alternative available to come up with a law that would keep the courts away, would be less interventionist in that sense, and is based on the model law that is there all over the world, and we need to start following that and be in step with what's happening all over the world. Now, in the as far as the ADR centers are concerned, I think there is huge human resource available to us of retired judges, but that is not a limitation. As the law also provides, there could be a number of other arbitrators that could be brought in, and that is something that we need to work with CIArb also and understand how do we go about training and certifying some of our judges, and how do we go about doing that. So this is all that I wanted to say, that it's about time that we reduce our delay of 5 to 20 years that is there in the court. The option is to move towards ADR through legislation, through judicial will, and later on jurisprudence will take care of it, and that is the only way we can do something about it. And in the end, I end with the quote of Julius Caesar, Shakespeare saying to Brutus saying, "There is a tide in the affairs of men, which taken at the flood leads on to fortune. Omitted, all voyage of their life is bound in shallows and miseries. On such a full sea are we now afloat, and we must take the current when it serves or lose our ventures." Thank you very much.